you for your testimony. The chair calls Jonathan Covey. Jonathan, I have you here on behalf of Texas Values registered for the bill. Is that correct?
Yes, sir, Mr. Chairman.
All right, go ahead.
Jonathan Covey, Policy Director for Texas Values. I don't want to be duplicative. I had some background information I was going to give you, but Representative Kane, Chairman Kane covered that very well. I want to address a couple things. Previous testimony. Texas RFRA has some protections, but this bill makes it much, much better. Texas RFRA was enacted to prohibit government agencies from placing a substantial burden on a person's free exercise of religion unless that agency shows that the application of this burden is the least restrictive means of furthering a compelling governmental interest. So this is a balancing test. Basically, it's a four-part balancing test, and it's based on a case out of 2009 called Barr v. City of Sinton. This bill is a really good belt and suspenders approach, which it takes away the balancing test on the issue of religious freedom so that activist courts are absolutely required to protect religious freedom for lawyers. So I would say it's better to be proactive and protect future discrimination when the opportunity is afforded to you. And Andrew and I go way back, and I appreciate his testimony, but organizationally, I'm also just shocked about the ACLU's position on this. Like Representative Schofield was saying, this bill will ensure that the state bar doesn't go after attorneys' license if they don't like what a lawyer says, or if they don't like their verbal conduct. If lawyers are having to defend their free speech rights, and they are, because we've heard about that already, the standard is not high enough, and we need a bill to heighten this standard. So I would ask you to just please support this bill. It's an excellent bill, and we appreciate the author bringing it.
Now I'm confused. Can I ask a question?
Yeah, sure. Representative Flores.
I'm sorry. Maybe I don't know enough about how a lawyer was about to lose their license because of what they said. Can you tell me how or how that would, how it manifests?
Sure. So this is based on protecting against ABA Model Rule 8.4G, which was a model
doesn't
rule.
exist in Texas, so there is no opportunity for that to happen.
Well, like we said, this would be a proactive.
I know it's preemptive, but tell me how a witness said that their father could lose their law license because of what they feel is their right to free expression. That's not the case right now in Texas, correct?
So this is protecting against and being preemptive. And like a witness said previously, by the time that a rule gets implemented, it'll be too late to do anything about it. This is making sure that lawyers are protected because, for example, if you're on a church board or you're a legal counsel for a religious organization and you say something, Model Rule 8.4G would have said that your verbal conduct might require you to be disciplined.
Okay, but it's not the case here in Texas currently. So I sit on lots of boards, and I don't feel threatened at all by the State Bar of Texas saying that I don't have the opportunity to, serve on whatever boards I want or feel that, align with my beliefs. So, so I wanted an example of how this could occur.
Right.
Like if a lawyer said what, for example?
Sure.
Like
did that answer your question?
No,
or
not really, but that's okay. I have to
for example, if a lawyer were to be talking in a
talk show,
in a seminar or a CLE course or something like that, and they were to say something against same-sex marriage, then if 8.4G were in place, this might actually threaten their ability to say that and their ability to have a license, and they could be disciplined for that.
Because it's an inappropriate forum to be saying something like that, expressing their views about somebody else's individual rights to
Well, 8.4G talks about regulating verbal conduct based on sexual orientation.
So a lawyer would be disciplined for saying something pejorative about a same-sex couple?
Could be.
Is that what you're saying?
Yes.
in a public setting.
It actually
like a
goes
CLE.
further than state and federal law protections that are in place.
But you do agree it's not currently the case, so the argument that it's not necessary at this point,
This was revisited by the bar, I think, as late as 2020. So they've considered it in the recent past.
but not approved it.
Members, other questions? Okay, thank you. Chair calls